A hush fell over the Supreme Court chamber as Elon Musk approached the petitioner's lectern. His dark blue suit was adjusted slightly, revealing a rare flicker of nervousness. The tech mogul had made the unconventional decision to represent himself, bypassing his phalanx of attorneys to make the case for a landmark challenge against what he called federal regulatory overreach. Across from him, Chief Justice John Roberts and Associate Justice Coney Barrett exchanged subtle, telling glances not missed by the tightly packed audience. "Mr. Musk," Roberts began, his voice firm and deliberate, "you've made the unusual decision to appear before this court on your own behalf." He paused. "However much you might do so, I must remind you that this is neither a technology conference nor a social media gathering." A soft ripple of laughter swept the room. Justice Barrett leaned forward, her voice laced with skepticism. "The legal questions before us are very complex. Are you certain you wouldn't prefer to have your attorneys handle this case?" Musk sat motionless, his expression unreadable, as the justices paraded their thinly veiled skepticism before he had spoken a word on the merits of the case. What followed would stun the courtroom, overturn long-standing presumptions about the law, and reveal a side of Elon Musk that few had ever seen. This was no publicity stunt of his. It was the beginning of one of the most unexpected displays of legal brilliance ever witnessed in the nation's highest court. Before we dive deeper into this historic battle, make sure to subscribe and enable notifications for complete coverage of today's most critical legal and political battles. Chief Justice John Roberts, 69, had been leading the court for nearly 2 decades. Roberts, who was admired for his conservative ideology and desire to uphold the legitimacy of the court, had led an increasingly polarized legal landscape with careful deliberation. His preparation was legendary, his knowledge of constitutional law nearing encyclopedic, and few had ever caught him off guard in these chambers. Justice Coney Barrett, 52, was the youngest justice on the bench. Despite having a relatively recent and contentious confirmation in 2020, she had already developed a reputation as an intellectual heavy hitter. A former Notre Dame law professor with a strict textualist ideology, she was renowned for piercing, surgical questions that seemed to have a way of exposing the soft underbelly of even the most carefully argued points of law. Together, Roberts and Barrett embodied the court's immense power, one that had long intimidated veteran litigators. Now, standing before them, was Elon Musk, 53 years of age and best known for revolutionizing electric vehicles, commercial spaceflight, and social media. Despite being admired for his engineering prowess, Musk was dismissed beyond the industry as erratic and unchecked. But, much to everyone's surprise, he had fired his attorneys and asked the court to argue this case himself. The case, ex-Federal Communications Commission, concerned whether the federal government could regulate digital speech platforms under the guise of the FCC. Lower courts had upheld new FCC content moderation rules, determining them to be constitutional exercises of power. For Musk's company, the economic stakes were colossal, billions of dollars in compliance costs and substantial changes to its business. But for Musk himself, the stakes were no less personal. The majority viewed him as a genius engineer, but an unsound thinker outside his specialty. This was a time of testing, arrogance or genius. Roberts leaned forward. "Mr. Musk, this court's time is extremely valuable. I hope your choice to argue won't be a waste of it." His tone conveyed that he considered Musk's action a circus, not a sincere legal undertaking. Barrett chimed in tartly. "Your prior counsel presented detailed briefs. I wonder why you felt they were insufficient." It was a tactical challenge. Either Musk would disparage his own team or acknowledge he wasn't needed. Musk played with the microphone. There was a wave of discomfort that swept the room. Most spectators were expecting a train wreck appearance by an out-of-his-depth billionaire. What they had not considered was that Musk had been rigorously preparing for this moment for the last 6 months, far more than even his nearest well-wishers had seen. "Thank you, Justice Barrett," he began, his tone calm and measured. "I have high regard for my legal team, but this case sits at the intersection of constitutional law, technology, and human communication, spaces where I believe I can provide this court with some unique insights. insights that even the most able attorney might find difficult to articulate without first-hand experience. The courtroom bust. Musk wasn't faltering. He was calm, eloquent, and composed. He continued, "The legal issues before us require more than standard analysis. They require understanding of how content moderation algorithms work, the real limits of AI in distinguishing lawful from unlawful speech, and the global ramifications of American digital legislation." Roberts and Barrett exchanged another look, this time less sure of themselves. As Musk began to collect his notes, the atmosphere in the courtroom shifted. What had begun as an attempt to bring down an arrogant CEO was beginning to sound very different. "Mr. Musk," Roberts went on, "your argument is that the FCC lacks authority to regulate these moderation rules. But the Communications Act gives the Commission broad discretion over interstate communications. Why should your platform be treated differently?" It was a classic Roberts strategy: get the advocate on the defensive. Musk didn't flinch. "Chief Justice Roberts," he replied, "I believe there's a more basic problem. The Communications Act was passed in 1934, long before the digital era. Although Congress has updated it, the sections the FCC is using were never meant to extend to algorithmic speech curation or user-generated content on this scale." Barrett cut in, her voice cutting. "That's a convenient interpretation, Mr. Musk. This court has repeatedly held that broad statutes can cover new technology. In Massachusetts v. EPA, we ruled that the Clean Air Act could cover greenhouse gases, even though Congress hadn't envisioned them. It was a trap. Quote a complicated precedent and wait for the non-lawyer to fall." But Musk was ready. "Justice Barrett, that precedent actually makes a critical point. In Massachusetts v. EPA, the court held that greenhouse gases are squarely within the statute's definition of air pollutant. The application was new, but the underlying principle was in accord with congressional intent." He appeared before the full bench. On the other hand, the FCC isn't just applying old law to new technology. It's transforming its mission. It's transitioning from regulating infrastructure to regulating speech. That's a legislative leap, not an administrative interpretation. Justice Sonia Sotomayor leaned forward, skeptical. "Mr. Musk, your platform reaches hundreds of millions. When disinformation gets out, it impacts elections, health, national security. Why shouldn't the government be able to regulate that, just as it regulates the broadcast media?" It was a difficult objection, one that had shaken experienced lawyers. Musk paused for a moment, then responded, "Justice Sotomayor, that analogy misses three essential differences. First, broadcast spectrum is a limited public resource, which justifies regulation. Digital platforms don't have that limitation. Second, users affirmatively choose to use our services, unlike unwanted broadcasts. And third, the content is mostly user-generated. That's more like a phone network than a TV station." By this point, Musk wasn't just holding his own. He was navigating complex legal territory with persuasive clarity. Justice Neil Gorsuch, a skeptic of expansive agency power, leaned forward. "Even if your interpretation of the statute is correct, Mr. Musk, why shouldn't we defer to the FCC's technical expertise under Chevron deference? This was the trenches of administrative law. When should the courts defer to agencies interpreting vague laws?" Musk dove in without hesitation. "Justice Gorsuch, this is exactly the kind of major question the court has said is outside Chevron's scope. In West Virginia v. EPA, you held that decisions of tremendous political and economic significance require clear congressional direction." He went on, eyes steady. "These regulations would recreate communication for nearly 2 billion people, recreate our platform, and effectively allow the FCC to police protected speech. If that does not present a big question demanding clear congressional authority, then what does?" The justices glanced around, at least visibly surprised. Barrett, who had been dismissive earlier, now seemed positively engaged. "Mr. Musk," she went on, her tone a little less acidic, "your briefs invoke Professor Lawrence Lessig's code as law theory, the proposition that software architecture regulates conduct in the same manner as legal regimes. Can you address how that is relevant here? It was an abstract, high-level question designed to push him up against his intellectual limits. But what came next caught the room off guard. Musk stepped away from the podium. His demeanor shifted, no longer defensive, but confident and in control. Professor Lessig's framework controlled the discussion, illuminating why traditional methods of regulation inevitably fail in virtual environments. Eyes on not a note at all, Musk dove into an unambiguous, advanced explanation that wove constitutional principles, technology facts, and regulatory theory. He began by asserting that when the FCC prescribes certain content moderation algorithms, it's not really instructing businesses what to do. It's writing law directly into the Internet's underlying architecture. It's important, Musk argued, because algorithmic regulation works invisibly and all the time, without checks and balances that come with traditional enforcement of law. To explain, he referenced Section 4B of the rule, which requires platforms to lower the visibility of content that is potentially deceptive. While it may seem straightforward, Musk explained that this subsection requires preemptive filtering regimes, systems that restrain speech prior to being legally vetted, in effect constraining expression in advance. And then Musk became constitutional. He noted that this type of system creates what the courts have traditionally found to be a grave problem: prior restraint. Referencing Neer versus Minnesota, he reminded the court that any legislation limiting speech before any abuse is scrutinized under the most severe level of review. Algorithmic systems, he warned, don't wait for abuses. Toxic speech gets censored on probability grounds. The courtroom fell silent. Even critics were amazed at Musk's expertise. He wasn't reciting talking points. He was marrying law and technology with uncommon lucidity. Chief Justice Roberts, whose expression had been one of skepticism, leaned forward, his face now creased with genuine interest. "Mr. Musk," Roberts responded, "that's a good theory. But let's talk about practical solutions. How would you deal with real threats like foreign disinformation campaigns without resorting to the very algorithmic tools you're criticizing?" It was a question meant to trip up any vagueness in Musk's position. But instead of retreating, Musk laid out a robust, detailed plan. His regulatory proposal was intended to meet government concerns while staying within constitutional bounds. "Chief Justice, I believe there are 3 constitutionally sound approaches," Musk responded. He described a system founded on transparency mandates, user control options, and selective enforcement against flagrantly illegal content. Each component was tied to existing legal precedent and statute, evidencing not just technical acumen, but legal agility. The justices were all ears. Justice Barrett, who was among Musk's loudest skeptics initially, leaned forward. "Mr. Musk, your model seems to borrow from Justice Kennedy's concurrence in Packingham versus North Carolina, which views the Internet as the public square of today. You then weigh it against the legitimate government interests. But how would your proposals operate under our current laws?" Her tone had shifted. She was now speaking to Musk as an equal. His reply was blunt. "Justice Barrett, Section 5 of the FTC Act can also support transparency and disclosure rules. For content regulation on the basis of content, rather than FCC mandates, Congress could pass narrowly focused amendments to Section 230. He continued with unprecedented detail. Musk held firm that keeping Congress in power preserves the separation of powers. He used FDA v. Brown and Williamson Tobacco, buttressing his case with precedent. What had started as an effort to take on a presumptuous tech CEO had become one of the most deliberative constitutional discussions the court had seen in years. The Solicitor General, who had represented the FCC, looked ill at ease. What had been a routine defense of agency authority now was met with a robust intellectual counterattack. Roberts, now deeply invested, asked one final question. "Mr. Musk, from a technical standpoint, why exactly is the FCC's algorithm regulation flawed?" This was Musk's opportunity to integrate his technical and legal arguments. Over the next few minutes, he delivered a masterclass on how content moderation systems operate, where AI cannot tell protected and harmful speech apart, and why mandatory systems would inevitably censor legal content, while missing harmful material. Even justices who are not technically savvy would have recognized the actual shortcomings Musk listed. He brought the debate back to First Amendment law with his conclusion. The FCC is insisting on a technical solution that just can't accomplish its purpose without actually causing harm to protected speech. This is precisely the kind of outcome First Amendment jurisprudence is intended to avoid. As he returned to his seat, the courtroom was subdued. The predicted trip-up of a tech billionaire had turned into a dazzling display of intellectual power. Roberts and Barrett exchanged one final glance, one of admiration. They had seemingly underestimated Musk. Within a few hours of the hearing, headlines broke out. Musk stuns Supreme Court. Tech tycoon outwits nation's highest court. Moments of the argument were posted widely online, and legal pundits reacted in amazement. "I've watched Supreme Court arguments for over 30 years," said Harvard law professor Lawrence Tribe on a news panel. Musk's presentation was among the most impressive I've seen from a non-lawyer. His integration of law, tech, and policy was remarkable. Social media exploded. Legal Twitter buzzed with argument. A well-known appellate attorney posted, "When Musk tied Kennedy's Packingham opinion to Lessig's code as law model, it was genius. He was not scripted. He was thinking through advanced legal issues in the moment." Behind the court's closed door, sources revealed heated argument. Justices reportedly acknowledged that Musk's ideas had deeply influenced their decision-making. 3 weeks later, the court did something unusual. It requested additional briefings on Musk's backup regulatory suggestions. This was a sign that his suggestions were being seriously considered, not simply routine deliberation. Scholars wrote essays critical of Musk's model soon thereafter. Professors added his oral argument to law syllabi as a lesson in digital era advocacy. Roberts and Barrett, both changed by the experience, shifted how they approached future tech cases. They posed more thoughtful questions, acknowledging their own fallibility. Barrett gave a speech at a law school event and stated that the case taught her not to underestimate unconventional knowledge. Roberts, speaking to the American Law Institute, made a candid assertion. As technology evolves, some of the best legal insight will be from individuals who understand it from the inside, more than just those with traditional legal training. For Musk, the hearing was a watershed moment. While continuing to be polarizing in business and in life, he had emerged as a serious voice in legal theory. Scholars who had previously spurned him were now beginning to take his views seriously. 6 months later, the court voted 7-2, pretty much adopting Musk's framework. Justice Barrett wrote the majority opinion, citing Musk's technical reasoning and endorsing a lot of his legal framework. She concluded by stating something that many interpreted as a nod to Musk himself. As technology continues to redefine Americans' exercise of First Amendment freedoms, courts must reconsider regulatory paradigms and be open to the views of those building these platforms. Where law and code intersect, courts must be capable of both legal humility and technical sophistication. The decision found its way into legal textbooks, not merely for its doctrine, but for what it represented. A turning point in the manner in which courts deal with free speech in the age of the internet. Legal scholars began calling it the beginning of Musk jurisprudence, a school of thought that privileged user autonomy and transparency over mysterious algorithmic commands, and one that compelled regulators to collaborate with technology rather than fight it. For the law establishment that once ridiculed him, the lesson was clear. Traditional credentials count, but understanding the systems under which they're operating may be more so. Musk, formerly a rebel whose impulsive streak had led others to dismiss him as irresponsible, had rewritten the playbook of digital constitutional law. What had begun as a challenge to his legitimacy had seen him reframing the argument for years, if not decades, to make.